Good afternoon. It is my distinct pleasure to welcome you to our final panel today, a very important one on human and people's rights in the African context. It is also my honor to introduce a truly remarkable lineup of speakers today. First up, Professor Ademola Oluborode Jegede. He's a professor of law at the University of Venda in South Africa. He's serving as an interim director of the Ismail Mahomed Center for Human and People's Rights at the same university. He's also the initiator and convening editor of the African Journal of Climate Law and Justice. Professor Benyam Dawit Mezmur, professor of law and deputy dean for research and postgraduate studies at the law faculty at the University of the Western Cape. He's also a member of the UN Committee on the Rights of the Child and a former visiting fellow of the Human Rights Program. Yusra Suedi is a lecturer, assistant professor at the University of Manchester in the United Kingdom. She is the director of the International Law graduate programs and co-directs its International Law Center. She's previously worked at the United Nations, at the International Law Commission, at the International Court of Justice. She also assisted as counsel acting for governments and organizations before that court. Professor Pedi Obani, who is joining us online today, is an associate professor at the University of Bradford School of Law in the United Kingdom and a visiting researcher in the water security policy and governance at the University of Leeds. She's also qualified as a barrister and solicitor of the Supreme Court of Nigeria. She has received several grants in international research grants and awards, such as the Global Challenges Research Fund in the United Kingdom and in African Studies. Last but not least, the Human Rights Program very own Abadir Ibrahim. Dr. Ibrahim plays a substantial managerial role in innovating and implementing academic activities such as today's event. Dr. Ibrahim has also served as the head of the Secretariat for the Legal and Justice Affairs Advisory Council of Ethiopia. Thank you very much for being here today. And with that, I will hand over to Professor Jegede, who is joining us online. The floor is yours for the next 10 minutes.
How are you? Good. I think it's night, eh? I don't want to say good night because that would mean I'm going. Yeah, it's such a pleasure for me to be part of this conversation. So I just want to share some thoughts in relation to some aspect of our theme. And I've titled my thoughts, Climate Injustice and the African States' Human Rights Obligations. So, the question I'm going to be addressing is what are the human rights obligations of states in Africa in the face of climate injustice? And I think this is so important because oftentimes, we chant in Africa the phrase, African solutions to African problems. But then that phrase is never so loud when it comes to taking responsibility to climate change. Professor Benyam, who started the conversation in this session, talk about the issue of, disproportionality, even when it comes to African spread of carbon emission. So oftentimes we don't talk about, that tiny aspect, as important as it is. So it's not always very loud when we talk about, climate change, the phrase African solutions to African problems. So our focus is always like, abroad, not within. And please do not get me wrong. I'm not saying that there are no valid reasons for that. But what we are saying is that when we say or use the phrase African solutions to African problems, it must be applied, at all times, because it's a phrase that presupposes a sense of responsibility, a sense of ownership, a sense of care. And, and that ownership, responsibility is never so necessary. It's never more necessary than at such a time like this when the world is struggling to cope with this global crisis that is posing existential, threat war. So because, in some part of Africa, for instance, when you talk about, when they talk about responsibility or accountability for climate change issues, it's always like, the NGOs who say that they are accused of colonial apartheid, populism setting among African elites, which I don't think is helpful to the situation if we see climate change as a global challenge. So, I'm going to be situating my brief presentation, in that context. I just want to say when I talk about climate injustice, I am referring to, I'm just trying to make an argument that, the phrase climate injustice should not, be used in such a way by African states to deflate responsibilities. Rather, it is an issue that calls for attention as to what Africa needs to do on its own in relation to climate change. So by climate injustice, I'm referring to the unjust systems that continue to drive climate breakdown, like economic growth at any cost. It also worsens existing oppression and further marginalize poorer and more vulnerable population. In that context, people do face multiple crises, and it becomes harder to deal with the impact of climate change because of it. It's also a phrase that generally it applies in African context because we live in an era where we are called to implement climate interventions while we face developmental challenges, which itself is an issue of climate justice between the North and the South. But I don't want to get into that. I want to just zero in on what responsibilities we need to make, because it's been overbloated. Historical contribution that the North has made to the current state of the climate, warranting their commitment to it, which is good. But my argument in this brief reflection is that states in Africa have obligation themselves to respect, protect, and fulfill rights to advance climate justice within their territories. So in terms of respect, I feel they have the responsibility to ensure that they themselves refrain from conduct that they foresee or ought to reasonably foresee will create or contribute to climate change. For instance, they should refrain from unsustainable using and depleting of natural resources, pollution and degrading ecosystems. Measures that they think will contribute to decline in biodiversity. They should make it a point of duty in relation to their obligation to respect and ensure that these actions are avoided. And of course, they are also expected to take some measures to create human rights risk, not to create human rights risk resulting from development and deployment of technologies for reducing greenhouse gas emissions. So they have that responsibility to ensure that right is respected in the context of climate change. And of course, states also must take necessary steps to ensure that they protect their population as long as it is under their control, to protect their population against substantial risk associated with climate change. They must adopt and implement appropriate legislative, administrative measures, for instance, and put in place procedures that will ensure that adverse consequences of climate change are addressed. We were talking about drought, we're talking about flooding. There are some measures which ordinarily states are expected to take, in that context. And of course, this also involves establishing special mechanisms, processes, or institutions to monitor and report in relation to adverse consequences of climate change. And this obligation also means that they should ensure effective and accessible judicial and other remedies for violation of rights associated with climate change. Because, that is a responsibility which no other state outside Africa would take or assume for Africa. African political elites must take up this responsibility to ensure that their rights are protected in the context of climate change. For instance, states will be in breach of their obligation to protect if they fail, for instance, to phase out fossil fuels, to be seen to take reasonable measures to ensure that they transit from fossil fuels to alternative energy source. So this is so important because in some part of Africa, when you talk about fossil fuel is like you don't want us to develop. What is the problem? Are you agent of colonialism? They use those words oftentimes. Which I think is something that we need to sort of address, because it's not helpful in the context of addressing the global challenge of climate change. It shows we are deflating responsibilities. So and that is so important. If they also fail to avert or minimize or address loss and damage associated with adverse effects of climate change, particularly those within their control, take measures to protect populations in vulnerable situations in the face of adverse consequences of climate change, will also be a breach of that obligation. So I know time is not on my side, but finally, states also have the obligation to fulfill human rights in the context of climate change. And it's only in doing that that they can say they are addressing climate justice, in so far as it depends on their control over the situation. I feel necessary measures to fulfill human rights in the context of climate change will be recognizing the interface that human rights have with climate change. It's still a debate in Africa, for instance, something that is long settled at the international level, the interface. There have been reports, studies linking climate change with all manners of rights. But then, it's still a debate we're engaging whether or not climate change, interfaces with rights in Africa, and who should bear the responsibility. We're still carrying out the studies at different scales of responsibilities for human rights, which I think, by now we should be over it. So then it also means that they must adopt framework legislation that allocates duties and responsibilities in relation to the fulfillment of. Happily, some states in Africa are putting in climate bill, climate law, climate policy. Some call it climate act. But then when we look at the content of some of these documents, you discover that they often lack human rights approach, which I think is so crucial in terms of bringing states and other agents, making them accountable for climate wrongs, particularly within their territories. So this is why putting in place legislation is so important, ensuring that those laws include provisions that allow NGO to sue, to litigate using human rights framework becomes so important in those climate act that is emerging. So I think it also requires the need to impose duties on states or non-state actors to carry out climate impact assessment, for instance, or before projects are authorized. That is so crucial. So and I think it also requires that the burdens of mitigating and remedying climate change and other forms of environmental destruction are not shifted to future generations, particularly insofar as it lies within the control of African states. So that's just my thoughts in relation to that. I just feel it is important that when we talk about African solution to African problems, African states begin to also take responsibility to some extent in relation to how to hold themselves accountable for, or entities within their control accountable for activities which underlie climate change and its adverse consequences. Thank you.
Thank you very much. Now, Professor Suedi.
Thanks very much, Angela. I just have a presentation. Perfect. Oh, excellent. Okay, thank you so much. I realize I might have to. Sorry, that's okay. Just because otherwise I can't. I'll have to turn it off to see. So, okay. Good afternoon, everyone. Thank you so much, Angela, for your presentation. Thank you for the organizers for allowing me to present some of my recent research, which I think is an excellent follow-up to what Professor Jegede was just talking about, and the need to think about how human rights obligations can really be enforced to African states. So I'm going to be talking about climate litigation before the African Court of Human and People's Rights. And this is based on a paper that I wrote where I focused on the African human rights system generally, but for the purposes of this presentation, I really want to focus on the court, and that's because any act of climate change litigation is essentially an act of public interest litigation where we are really strategically targeting the highest judicial authority or a judicial authority who can make the pronouncement that can really lead or generate the change that we're looking for. And so the African Court would be the most appropriate body. So the African Court obviously has its contentious avenue and its advisory avenue, and I just want to ask some very simple questions about what that might look like to give an idea. So the first question, if we're looking at the contentious avenue, could individuals sue states before the African Court? There would be value in this. So for example, this confrontational spirit behind a contentious proceeding might be exactly what we're looking for the purposes of public interest litigation. And of course, we would get a binding decision out of it, which is something that could be very promising when we're talking about human rights obligations to respect climate change. And of course, in the wider context of everything else happening around the world, this would contribute to the snowball effect and have a further snowball effect in other parts of the world to advance the enforcement of human rights obligations. But there are potential problems that I want to briefly discuss. So there's a potential problem of victimhood, which I think is no longer really going to be a problem. There's a problem in terms of who can be sued. And there's a problem of course, exhausting domestic remedies. So if we first address the issue of victimhood, essentially proving that you are a victim as somebody who is suing a state before the African Court, this has been complicated before other UN bodies and courts of late. And it's essentially proving this causal link, which is twofold. So proving first that there's a causal link between the state's inaction and climate change, or action and climate change, and between climate change and the violation of the individual's human rights, right? So it's twofold. I think that with the climate science, we've seen a couple of examples now, domestically and internationally, where this has been established. And so I don't think that this is much of an issue. And more specifically, when we're looking at the African Court, it's very promising that the court accepts that harms can be collective. And also, public interest litigation is accepted before this court. So the claimant does not even have to be a victim for the violation. And this is different compared to the European Court of Human Rights, for example, where this is not the case. And so this would actually make litigation before the African Court a pretty promising endeavor in that respect. That being said, there are other things that could be issues. For example, who do we actually want to sue, right? Who are we actually targeting? As was mentioned earlier, individuals and NGOs can submit complaints directly to states who have made special declarations. So the state must have made a special declaration. We're looking at Article 34, Paragraph 6 of the Protocol to the African Charter, which essentially has established the court. So we have 34 state parties in this image here to the Protocol to the African Charter. Of those, only the ones in green are the ones who have made a special declaration saying that an individual or an NGO can sue them. So you'll see that there are actually very few. And recently, there has been, in the last couple of years, between 2019, 2020 especially, there were a few states who pulled out of that and said, I actually don't want to be sued by an individual or an NGO anymore. And so this has, created a sort of tension. But this process does exist. And so, if we look at who exactly can be targeted, are these really the highest emitting states on the African continent? Not particularly. So that's also a question whether, this would be a worthy endeavor. And finally, this famous and very important requirement to exhaust our domestic remedies, right? So try out in your local system before going to the regional system. And in other climate litigation cases, this has actually been skipped. So, for example, in Sachi, Argentina, which we spoke about with Benyam yesterday, the children actually said, this is a climate emergency. We don't have time to go exhaust domestic remedies. We're going straight to the committee. And of course, as we heard yesterday, that was not upheld by the committee. Now, mark your calendars, because on the 9th of April, we will have the judgment in 3 climate litigation cases before the European Court of Human Rights, where, in the occasion of Duarte Agostinho, these Portuguese children also skipped this requirement. They did not exhaust the local remedies or domestic remedies, saying, this is a climate emergency, we don't have time to do that, right? And we'll have to see what the European Court says, whether it upholds that or not. So we'll see whether that actually could possibly be a precedent for an African case in the future, or whether it will not, right? So a question mark at the moment. But if that's not the case, then we have to prepare for the fact that this could take time, right? Because we first have to exhaust domestic remedies before going to the African court. So something else important to consider. Now, that was a little flavor of what could go on contentiously. Let's look at the prospect for an advisory opinion, because we've seen that at the ICJ, at ITLOS, at the Inter-American Court. What about the African continent, and why would that be important? Well, because it could reinforce and enter into conversation with some of these other advisory opinions that are coming out. But more importantly, and earlier we had a panel about common but differentiated responsibilities. And we also heard earlier that we only have 11 states participating in the ICJ advisory opinion. And I was on a panel the other day talking about this very subject, where another speaker, whom I shall not name, said, but we don't actually need an advisory opinion from, an African court, because the ICJ advisory opinion will pretty much cover everything that African states need to know. To which I raised my eyebrows, because I'm not entirely convinced about that. I actually think that an advisory opinion could be valuable in spelling out the obligations that are really particular to us on the African continent in the wider climate context. But there are some problems, again, potential problems to look out for, and I'll mention 2. The first is, of course, that advisory opinions are not binding. Now, I don't think that's too much of a problem if we consider that this is essentially an authoritative decision. It can influence domestic law and policy making. It can have a binding effect. It can lead to compliance. It can lead to consequences, as was seen with the UK going to the negotiation table with Mauritius following the Chagos advisory opinion. And of course, we can also consider that, again, if we're talking about public interest litigation, we care about protest, we care about pressure, we care about process, and perhaps that can outweigh the more simplified outcome of just having a binding decision, right? So all of those things to consider. And of course, another issue would be who is making the request for an advisory opinion. Now, on the African continent, what is wonderful is that NGOs can actually make a request for an advisory opinion, which would be great for the climate crisis, right? However, there have been many rejections that the court has made to requests by NGOs. So we've had 15 requests, 11 by NGOs, only 4 advisory opinions have ever been emitted. And that's mainly because the NGOs have to fulfill many very specific requirements that might be difficult for them to meet. So they need to be recognized by the African Union. Here's a sample of some of the requirements that they have to meet in terms of how they're financed, in terms of their structural requirements, et cetera, et cetera. So that would be, a potential hurdle to jump through if we're considering this. overall, I'm more optimistic. I do think that individuals could sue states before the African court. I think there are good prospects for victimhood. I think that we have to be cautious about the time that it could take and the limited states that we could target. And an advisory opinion, I've explained why I think that could also be very valuable. But of course, we have to be wary that if the NGO is making the request, they will have to meet certain requirements. So I hope that sheds some light that can contribute to this conversation about human rights, and I thank you for your time and attention.
Thank you, Yusra, for staying within the time so well. Now, next is Professor Obani, online.
Hello, good day, everyone. Thanks to the organizers for having me. And it's really been an exciting 2 days listening to all the panelists and interesting conversations. For me, I'll be focusing on the intersections between climate change and human rights, but mainly from the perspective of women's rights. Now, clearly, human rights offers pathways for advancing climate justice for women. But at the same time, we see that climate change is impacting on women's rights. But I think that to a very large extent, the opportunities which human rights law offers for addressing climate change impacts for women, especially adverse climate change impacts, is still largely unexplored within the African context. So if you look at the jurisprudence from the regional courts, from national courts, there's still a lot to be desired in terms of advancing women's rights issues in relation to climate change. Now, the thoughts I'll be sharing with you within the next few minutes are mainly based on the research that's been recently published as a book chapter in a book edited by Bauer, Etemere Field, and Jegede as well as a recently published conversation piece. Now, why am I focusing on women? Sometimes people ask the question, I mean, we're still grappling with climate change and human rights. Why do we need to think about women's rights as well? I think to start with, I'd like to draw your attention to issues around literacy and access to education levels. Now, there is a lot of progress that's been recorded in recent times around literacy levels within the African continent. But even so, the records show that actually literacy levels amongst youths in Africa is still one of the lowest around the world. And if you think about adults, you see that whilst the records show that 7 in 10 men can read, for women, it's only half that number. Now, we've talked a lot around what's Africa doing? Are we in the spaces where these conversations are being had? Are we contributing to the jurisprudence? And I think that in itself supposes that we can all read and write. Not even to think about the legal jargons and all the principles and technicalities that come with it, but there is just this assumption that we can read, we can understand the language of communication, and we can engage with the processes, the paperwork, the policies, and all of that. But if we think that the literacy levels are low, and low for women especially, then this is a significant barrier to accessing information. And this includes information not just about your rights, but also information around climate impacts, around climate data services, and indeed information around how to cope and be more resilient to climate change. So these are real issues. And of course, if you look at the STEM subjects, so science, technology, engineering, and maths, again, the statistics show that women are very often underrepresented in these spaces. And it's not necessarily a capacity issue. It has to do a lot with gender equality broadly. The second thing I want to draw attention to is the fact that women and women-headed households are very often amongst the poorest in various countries. And this also means that they lack access to basic resources, livelihood resources, and also the kinds of assets that are required to cope better with climate change. So if we think about climate adaptation, we think about mitigation strategies, we see that women are at a loss because they're very often poor and they do not have the resources that they need. Now, the third thing I'll say as part of my background scene setting is that gender norms in many societies also very often inadvertently increase women's vulnerability to climate change impacts, especially adverse impacts in very many cases. Now, this could be as basic as because of the clothing women have to wear, which raise safety concerns in emergency situations. It could also be because women have caring responsibilities, and those caring responsibilities become more difficult to deliver in situations of resource scarcity or degradation of the environment. And all of this contributes to stress. Now, in the previous panel, I think it was Dr. Adejomo who mentioned the fact that there are also concerns around violence against women in relations of climate change and adverse impacts. And these are real concerns in many situations. So women are exposed to levels of violence, they're exposed to cultural rights violations, mostly linked to environmental degradation, but also scarcity of resources. So all of these really, for me, points to the fact that we need to start paying attention to women's rights and how climate change is impacting on the rights. I'm not going to talk about the health aspects of this, but there are lots of indications that women do suffer health impacts as well. So moving on to that, moving on from that, is there a legal basis for action, or is this just, something we need to do because women are affected? There is a legal basis. If we look at the International Bill of Rights, I think there's a clear understanding that we have to work against discrimination. So international human rights law already prohibits discrimination based on sex, and this in itself provides a strong legal basis for advancing gender equality at the national level, at the subnational levels, of course, at the regional level as well. Now, still at the international level, if you look at the Convention on the Elimination of Discrimination Against Women, we will see that it clearly outlines processes, guidelines, practices that need to be respected in order to promote women's rights issues, cultural rights, civil political rights, economic rights, and all of this taking into account women in vulnerable situations, including those living in rural areas. And I think this is really important because, as I'll speak on later, it's not just about, when we talk about women and women's rights, we have to remember that women are in different positions, are in different situations, and this has implications for their rights as well. So the right to freedom from discrimination is enshrined in most national constitutions also. Sometimes we have it as freedom from discrimination on the grounds of sex or on the grounds of gender. Notwithstanding, the law doesn't always seem to be on the side of women. So there are still examples of laws and policies which prohibits women from equal access to land, property, housing, and we still find women experiencing various forms of gender-based violence, women being denied access to sexual and reproductive health rights, but also women being discriminated against in the workplace, and this limiting their access to economic opportunities. Now, all of this coupled with the vulnerability to adverse climate impacts does create more complexities as well as stumbling blocks to women realizing their rights in the face of climate change. At the regional level, we have the protocol to the African Charter on Human and People's Rights on the Rights of Women in Africa, the Maputo Protocol, which in itself recognizes a range of women's rights, including cultural and environmental rights. Now, the Maputo Protocol, of course, complements the African Charter on Human and People's Rights, which recognizes our right to a healthy environment for our development as people on the continent. Now, Article 18 of the African Charter specifically calls on states to eliminate discrimination against women and to protect women's rights in line with international declarations, conventions, and all of that. And there are also examples of sub-regional legal instruments which address women's rights issues, but I won't go into all of that. What I'd want to say at this point is that in thinking about women's rights, in thinking about women's rights issues, gender equality, we have to adopt an intersectional approach. Now, this is critical to understanding women's rights and climate change intersections. This is because some women would suffer more adverse impacts than others. At the end of the day, all women are exposed to some form of discrimination or the other. If we look at the World Economic Forum's Global Gender Gap Report, for instance, it does state that there's no country that has achieved full gender parity on the 4 key dimensions that are measured. If we look at economic participation and opportunity, if we look at educational attainment, health and survival, political empowerment, women are still behind. And this is as of 2023. But the good news is there is at least one African country that ranks at the top 9 for achieving at least 80% in closing the gender gap, and that is Namibia. So I guess there's something to celebrate there for the continent. All the same, we have to remember that each woman's experience of climate change impacts would therefore be different, but very often would likely be worse off due to additional identities that increase their vulnerability. This could be their age, this could be their level of education, this could be poverty, it could be where they live, whether they're in rural areas or in urban areas. So there's so many factors. But in the end, it is not all doom and gloom. And this is because when we look across the continent, there are examples of laws being passed that are focused on promoting women's rights and gender equality. But of course, there's also pushback. For instance, in the recent weeks, we've heard about issues around female genital mutilation and the pushback from people who would rather not have that as well protected, would rather not have women's rights protected in that regard. But that's not the issue being discussed here today. Now, if we look at the climate change framework in African countries, and that's the third main thing I want to focus on, can we say that the climate change laws are advancing women's rights? I think that if we have an overview of the climate change laws, we've talked about the Nigerian Climate Change Act, for instance. Other panelists have mentioned the Kenyan Act and other countries. So we have laws in Kenya, in Nigeria, Mauritius, Uganda, South Africa is coming up with a law as well. And I think if we look at the laws, it really presents a mixed picture at best. So if we think about whether or not the laws are providing opportunities for women to access justice through the courts, we have to start with asking ourselves, what do the climate change laws provide for? Now, a lot of laws actually provide for women to be represented in the climate governance process, which I guess is good. You know, it's great that we're thinking about having women in the decision-making spaces. But I think it's also important if you reflect back on the statistics I mentioned at the beginning around literacy figures and around women's representation in the STEM and in other domains that are required for climate action, then there is a gap. It's not enough for the laws to say, let's have women represented in the decision-making processes if women aren't enabled with the right resources, the right education, the right knowledge tools to be able to contribute meaningfully to that process. So that in itself is likely to create a situation where we keep perpetuating the gender gap. And there's also intergenerational inequities because the women are really not enabled to contribute meaningfully to the process. So the participation could be there on paper, but it's not effective. The second thing I would like to reflect on is that when we think about gender, I think some of the panelists also mentioned this, gender features prominently in some nationally determined contributions. But what we find is that there is paucity of data on the ways in which climate change impacts on women, but also this is not only a climate change issue. If we even look at the Sustainable Development Goals broadly, there is paucity of data on very many aspects of the gender-related dimensions of the SDGs. Now, what this means is then that we are not able to provide the support that is needed because we don't even know where the gaps exist as much as we should do. And if we look at the experiences of the women in Switzerland with the Cleaner Scenarion versus Switzerland case, the need for data cannot be overemphasized. Because if women want to be able to go to court and get justice, they have to be able to show that there is indeed a loss that has happened, and that loss needs to be substantiated with the data. So that is another area for intervention. Now, the third thing I would like to say is that there needs to be a critical evaluation of the role of law.
Professor Obani, if you could just wrap up in the next 2 minutes or so. Thank you.
Will do. Thank you. There needs to be a critical evaluation of the role of law in relation to gender equality. Are women being represented in the courts as judges, as lawyers? We still have laws which do not really promote women's equality. So that is something the law needs to respond to. In conclusion, I'd like to remind us of Mary Robinson's admonition that climate change is a man-made problem and must have a feminist solution. Feminism doesn't mean excluding men. It's about being more inclusive of women, and in this case, acknowledging the role that women can play in climate change. And to that, I'd like to add that feminism in this case is also about ensuring that women have a conducive environment and also have access to the resources that they need to become more resilient and effectively play their role in tackling climate change. This is the right thing to do, and it's also a human rights imperative. Thank you.
Thank you very much, Professor Obani, for drawing attention to the issue of gender equality and climate change. And with that, the floor is yours, Dr. Ibrahim.
Thank you. Good afternoon, everyone. Good afternoon, Cambridge. And for those of you from Africa, we're really sorry. We understand it's late. Bear with us. If anyone is coming in from Asia, good morning. Okay, so my presentation is based on a paper myself and Angela are writing. And so in the Q&A session, if you have difficult questions, you can ask her. When we were writing this paper, everyone on this panel came up so frequently. As we read into Africa and climate, Africa, the human rights system and climate, Jegede, Benyam, Yusra, Obani, all of them were coming up in their publications. Thank you so much for making things easy for us by covering some of the things we would have had to cover on our own with your publications. Now, having said that, I would like to start with maybe a provocation, a disagreement with Jegede and Yusra on African solutions to African problems. Because, not a disagreement, I'm just being provocative. Because our research is actually based on the notion of the question of whether the African human rights system is able to provide African solutions to global problems. And the answer we're hoping for is a yes. Of course, we can, I think we have found that the answer is yes. The question now is it a big cap Y yes or a small y yes? And this is, before I tell you why, let me say that I would like to propose a view, like a visual of the African system of human rights as a three-legged stool. One of the legs is the African heritage. The Banjul Charter calls it the African civilization as well. There's a commitment to the African heritage, and then there is a commitment to the human rights movement. And there's also a commitment to contextualization at that moment, to the political context of when the charter was being drafted. And that political context evolves. It's not permanent. None of the three elements are permanent. So the reason I put it this way is because this troika explains why the African system is different from the global system. Because the African Charter derives inspiration from the UDHR. But why is it different? One way to answer this question is contextualization. But how does the contextualization come about? It's either inspiration from the political context of Africa that the contextualization comes, or it's from commitment to the African heritage, or it's tension between these three components. Now, the reason I put it this way is, I'll come back to this introduction because it gives you a flexibility of a tool of understanding the African system and why it's different, but it also gives you space for creative interpretation. Now, I'll come back to that. Coming back to the question of can the African system provide African solutions to global problems, the answer is yes, because you already have some components of that, for example, in its approach to collective rights. Yusra has covered this. I don't have to say more on this. It adds a layer that is otherwise unavailable. If you're taking individual rights, you would be limited in doing climate justice work, and collective rights overall gives you another tool, another layer of protection, because human existence, whether in Africa or not, but let's stick to Africa, is more than just individuals coming together. It is collectivities living together, and climate change sometimes affects us in a way that might not necessarily boil down to individual rights. And collective rights gives you that other dimension from which to approach, so substantively, not just from a legal strategy point of view. The other one we look at is the right to a satisfactory environment, sometimes defined as the right to a safe and healthy environment. And what we found is a range of state duties that come from that right. And the Obani case is important here. And there are other bits and pieces of soft law and other cases in which the African human rights system defines, from starting all the way from a duty to prevent all the way to remedy, and procedural rights and duties as well. Now, this is, and by the way, we explore what's already there, and we also explore what the potentialities are. Everything you see in the right to a satisfactory environment in the African system, you could imagine as having corollaries in climate law, like the South African court did earlier in Angela's example. It was climate impact assessment, right? So all those things may translate to climate as well. By the way, could you give me a sign when we are like 5 minutes? We are ready? Okay. Okay, so now all these are, I can't go into the details, but the African system has all these small steps, small improvement. There are non-improvements as well, by the way, but the focus is not that at this moment. The focus is on the improvements. You look at the Children's Convention, you look at the Women's Convention protocol, you look at the refugee protocol in Africa. All of them take small steps that are more progressive than the global system. And you have that possibility because of the troika I referred to earlier, and the potentiality that exists when, this is why the African system is not exactly identical to the global system. This is where the differentiation comes. Now, the next question, the big question, so all these are small steps. The next question we ask is it possible to have a big leap? Can we, within the African system, make a case for the rights of nature? With, of course, if the answer is yes, that would be the big why yes. And you'd have implications, procedural implications, substantive implications. We'll not go into that. But there are a couple of ways that you could get to that answer, to a capital Y yes. The first question is, are there treaties that provide for the rights of nature? Jegede makes a valiant treaty-based argument for this position. He succeeds in that, but I think it's unlikely for a rights of nature argument to stand just on treaty. You can make, and I don't believe this argument has been made. You can make a case for a common African standard argument based on African constitutions. If you look at the right to a safe and a healthy environment, or the right to a satisfactory environment, over 2/3 of African constitutions already accept that. Most positive laws in Africa accept that. So that one, you don't need to make that argument because the African Charter already, clearly accepts the right to to a certain standard of environment. But the question is, can you make a case for the rights of nature based on the common African standard argument? And by the way, the African Commission or court do not have the common African standard jurisprudence. So I'm coming up with a possibility here. So 1/3 of African constitutions, and there are no African constitutions that explicitly recognize the rights of nature. However, over 1/3, not over 1/3, I think almost 1/3, we haven't done the full tally yet, by the way, of constitutions impose a duty on states. Some of them impose a duty on all citizens or on all human beings. Some refer to multinational corporations. If these states, citizens, multinational corporations, NGOs have a duty to protect the environment, that's what they declare. Can you make a Hofieldian argument and flip that into arguing that the environment has a right? Because rights and duties are, two sides of a coin. Now, that is a viable argument. However, can you make a common African standard argument based on 1/3 of constitutions? And one thing we haven't explored is positive laws. There are a couple of really there's one country, I think it was Uganda, in its positive law explicitly recognizes the rights of nature. That takes me to my third possibility. using positive law is, I think it was Uganda, has explicitly recognizes the rights of nature, and with all its procedural implications, i.e., standing issues are resolved explicitly, positively too. Most African countries, however, also recognize the rights of nature and then also go into procedures of what that means. Recognize the duty towards nature, and that means that you can represent nature without having cause. So they make it justiciable. So you can bring all these things together. And if I'm out of time, give me one more minute. So these can kind of point you towards a possible positivist argument for the rights of nature. However, and this we haven't discussed fully yet, I don't think these are enough because you can base yourself on a positivist argument, but I don't think it will take you far enough. And this is where the three-legged stool comes in. Can you go towards the African cultural heritage and find arguments for the rights of nature there? And that is probably what will take us to a yes, but it's going to be difficult because the African Commission and the African courts have only recently recognized indigenous African legal traditions as coexisting with positive law, with positive Westphalian state law. And that's in the Androis and Ogiek cases. You see for the first time the commission first and then the courts look at the right to property and say, look, if you take the right of property, mainstream, modern notions of the right to property, these indigenous groups don't have the right to property over their land. So they take the definition, 10-year definitions of the Androis and Ogiek and turn that into an argument for that. So they recognize that indigenous legal system and translate that landholding into ownership, collective ownership. So previously, by the way, Africa is a legally hybrid place. Like since colonialism, indigenous legal systems have existed, and if you don't know, surprise, they still exist. So which means that there's legal hybridity is a fact. It exists. Indigenous legal systems exist. But most of the time, the indigenous legal systems have to adapt. So there's plurality and there's hybridity. And most of legal hybridity in Africa is indigenous systems adapting to modern legal systems, to the modern legal systems. Which, for example, even in the Androis and Ogiek cases, you see that because the mere fact that these indigenous people came to the African Commission in court is they're going to our legal system and making a claim. So that is legal hybridity. And interesting enough, both establish NGOs and kind of take their indigenous leadership system and translate it into that NGO system. And this is like one legal system adapting itself to another, to the more powerful one, in order to be able to assert its, in order for the group to assert its interests. One more minute. And so, for the first time, the African Court and Commission meet the indigenous people halfway and actually recontextualize the notion of the right to property as a collective right, and the right to religion too, by the way, as a collective right. So which means that what the Commission and Court are doing in this instance is they're reinterpreting the Western notions of property and religion to basically fit the indigenous context. And so this is one step that, in which you could see, like if you think about indigenous traditions in Africa that are ecocentric, rather than them being custom, tradition, or something lower than low, if you recognize them as low. Now you have the possibility of adapting our law, the modern law, and to adapt it, to take it a step closer to the indigenous legal system, and therefore create the potentiality for creating new things that would otherwise haven't existed through positive law, through treaty making, and so on. Let me stop here. I have a lot more to say, but hand it back.
Thank you, Abadir, for presenting the African solutions to a global problem like climate change. And now the floor is Benyam's.
Thank you very much. And I appreciate the opportunity to add a few points. One of the advantages that you have when you're the last speaker is you can say, I agree with all of the above, so let's open the floor. But I'm going to add a few points. Let me split my time, and the last 5 minutes I'll talk about children's rights. That's, to a certain extent, mostly my bread and butter. But I just also want to make a few observations in the first few minutes. Don't get me wrong. I love human rights. That's what I studied, that's what I do. And I appreciate the significant contribution that it does to a better world that we can all live in. But in relation to the conversation about climate change, I increasingly appreciate the reluctance to acknowledge the added value of using a human rights lens. There is some level of reticence to embrace a human rights lens. We often talk about the Paris Agreement mentioning human rights in the preamble. Do we want cookies for that? It's actually a clear indication that there is a pushback on the role that we want to have in relation to human rights and climate change. So it's a very limited role that has been identified in there. So we need to acknowledge the fact that the United Nations Framework Convention on Climate Change and human rights regulatory frameworks have, for the most part, proceeded separately. And we're increasingly trying our best to bring them together, but it's an uphill battle. I did some work for the African Union and a couple of organizations this year and last part of last year. And I remember that these silos are not just only at the regional level, they're also more pronounced at the national level. We sent out questionnaires to ministries within governments, asking questions about children's rights and climate change. We received some of the feedbacks, and some of it actually says, we don't want to answer this question because the department that is dealing with this issue doesn't involve us. So pretty much one department of government accusing the other. In the majority of instances, those that are actually in the margins are the ones from Ministry of Justice, the ones that are actually dealing with human rights and so forth. Those that are actually doing quite a lot of this work are those in the economy, climate, environment, and so on. So that separation is very much pronounced. So we need to acknowledge that there is a lot of work that is being done in silos that we need to try to bridge as we move forward. Now, having said that, we talk about the climate emergency is not short of superlatives. Among other things, it's being called the biggest issue of our time, our greatest existential threat, changing the world for us in unprecedented ways, which basically means it has significant implications on human rights. It has significant implications on human lives. But the sense of urgency with which we're actually moving is not matched by some of these superlatives that I described. And in Africa, it's even much worse. Now, when we talk about these silos and some of the role, an important role that human rights needs to play, you can actually arrive at some very drastic conclusions. I'll tell you one that I heard, a conversation that I had with a human rights lawyer who actually said, if you follow the COP process and assess it from a human rights lens, the best conclusion that you can arrive at for African countries is that they should actually boycott the process. Because human rights hardly inform the conversations at the COP process. In fact, if you're talking about the Paris Agreement about the 1.5 degrees, that is what was considered to be politically palatable. That's not necessarily the one that will help us to uphold human rights left, right, and center. If you're talking about food security, there is a clear indication, even if we were to reach 1.5 degrees, food insecurity will most probably be significant within the African continent. If you ask the World Food Programme, they're talking about the notion of taking food from the hungry to feed the starving. They're taking rations from Yemen to provide to people in Burkina Faso. They're taking rations from Mali to provide food for people in South Sudan. So the human rights lens still plays a very limited role. One of my heroes, I would call him, Jeffrey Sachs, he also mentioned about the fact that these negotiations about climate change should be taken away from the politicians and should be given to scientists. Now, that might have its own appeal to it, but I'm also not sure to what extent human rights will have a share if it was actually given to scientists, and I'm being too optimistic, it will remain in the hands of politicians. Let me mention two emerging issues that I see within the African continent that have not yet been mentioned in the conversation that we've had today. One is, we know about outsourced jobs, but we currently have what we call outsourced pollution. Many wealthy countries have effectively outsourced a big chunk of their carbon pollution overseas by importing more steel, cement, and other goods from factories in China, other countries in Asia, but also Africa. I see a significant role that the human rights framework can play in this regard in addressing this challenge, but it's not getting the necessary attention. As one commentator put it, if a country is meeting its climate goals by outsourcing emissions elsewhere, then we're not making as much progress as we thought. And as Africa, we are receiving the short end of the stick. If we focus more on air pollution and less on climate change litigation, will we actually be able to make more progress? Maybe so, because pollution is a great killer. The low quality of air that we breathe should be regarded as a crisis, including on the African continent. One of the challenges that the climate narrative faces is that it is increasingly seen as something that is further down the road. You know, we've talked about the ozone layer, the opening in the ozone layer since the 1980s, and people still talk about the fact that, you know, like, we're still here, we're operating. So they don't see the sense of urgency that we need to address, and maybe a role for air pollution litigation, addressing the climate change issues through air pollution legislation and so forth, might contribute a better opportunity than the path that we've taken as far as climate change litigation is concerned. Now let me come to children's rights. We often say disasters are the greatest equalizers. I beg to differ. Unless you're watching Tom and Jerry, disasters are not the greatest equalizers. Disasters do discriminate. We often talk about the climate crisis as a child rights crisis because children find themselves falling between the cracks in many, many occasions. Now, let me talk about non-discrimination. Non-discrimination is very important. Children with disabilities, girls. For instance, we talked about gender, right? I often go to a very sad example from Pakistan, where during the flooding, a father was actually holding on to his daughter and his son, and he could no longer hold because of the pressure. And he had to make a decision, and he had to let go one of them. And you can guess who he actually let go. If you talk about the Central African crisis, if you talk about the COVID crisis, if you talk about the South Sudan crisis, the Yemen crisis, and so forth, they're not child rights neutral, they're not gender neutral, so they affect children significantly. So if you talk about non-discrimination, there is an argument that the so-called sacrifice zones, for example, by definition, regions rendered dangerous and even uninhabitable due to environmental degradation, are in effect racial and ethnic sacrifice zones. And the African continent needs to look at this very closely from a human rights lens. The role that best interests plays is absolutely critical. It's a procedural positive obligation of states that can be very critical. In this respect, the principle would require children's rights be considered when climate and environmental obligation of different actors and environmental decision-making processes at the national and international levels are defined. For example, consideration of the best interest of the child principle in decision-making related to adaptation and mitigation measures would support to clarify the obligation of states under the different obligations that they have in Africa. The right to life is absolutely important. Juxtaposing this in the context of climate change impacts that affect the right to life of children, a few complex questions need to be raised. Do climate change impacts, floods, droughts that lead to loss of life lead to an automatic claim against the state? In what circumstances do such situations lead to claims? Does it matter if the loss of life is as a result of a slow onset or sudden onset event? What if the climate change event that led to the death of a child is predominantly caused by a non-state actor? Does causation have any relevance? And if so, how should causation be addressed to determine the accountability of a state? The right to be protected from violence is absolutely critical. It's a child rights matter. Climate change is a threat multiplier. In general, children's vulnerability to violence increases in the context of disasters, including those that are climate-induced. The whole gamut of protection provisions that are provided in the African Children's Charter, the Convention on the Rights of the Child, whether it's on the right to a name and nationality, the rights of children with disabilities, child labor, and so forth, is absolutely important. In fact, one of the significant contributions of the child rights lanes, the human rights lanes in the context of climate change, is to be able to address the adverse effects of mitigation and adaptation measures. Look at electric vehicles. They're very important. But is it not driving child labor in South Sudan, the Democratic Republic of Congo, or Chad, or Zambia? Look at the instances where conservation efforts are being made in Togo and Gabon and so forth, but are they not keeping children from indigenous communities to live outside of those environments, where their right to life, survival, and development is actually affected? The right to social protection is very important. There is ample evidence about the important role that social protection programs in protecting persons in vulnerable situations, living in extreme poverty, from destitution, including against climate shocks, play. The absence of social protection systems for children affected by climate-induced impacts is prevalent. For example, the ILO has identified that a majority of children affected in the food crisis in 2022 lived in the 67 countries where there is no national statutory cash benefit. When African countries, like the example that I mentioned from President Museveni, that says, you know, yes, we understand about the importance of renewable energy, but reliable energy is our priority. It's also to expand and provide social protection measures, and they find themselves between a rock and a hard place. Let me conclude. At least 42 African countries have constitutional provisions guaranteeing protection of the environment and or the right to a healthy environment. But if you ask children in Africa, they're actually saying, if every promise was worth a penny and kept, we would have been millionaires. I leave it at that. Thank you very much.
Thank you, Benyam, for this powerful contribution. So we're running out of time, but we want to make sure that we have time for a few more questions from the audience.
Thank you. I really enjoyed this panel. My question is to Abadir, but Sarah, you can also, Angela, you can also answer if you want. And your paper, really fascinating. I'm also working on rights of nature things in Africa, and I wonder if you've considered non-legal principles, so cultural principles like Ubuntu, and arguing whether that can play a role in the legal recognition of rights of nature. And more recently, there's been quite a bit written on eco-Ubuntu even. So you might want to look at that.
Thank you so much. I listened very carefully to all of the panelists since this morning, and I learned a lot. Congratulations to all of you. I do not have any questions, but it is general comments. In fine, it is legitimate for African countries to seek and to ask for compensation for damage, for reparation, and as Africa is a victim, as we are saying, we are not an actor, but we still have to assume our responsibilities and to work on ourselves as Africans. For this slogan, African solutions to African problems, I do not agree, especially in climate change. Climate change are not African problems. We are not the ones who've created this climate change. So I think that maybe to tackle this, I do agree that this fact, we have to tackle it globally. Someone says such issues, we have to tackle them through a multidisciplinary approach. It should be multi-dimension, multi-sectorial, multifunctional, both preventive and corrective. I do agree also that we should involve all the actors together. It is not only about politicians, it is also about lawyers, academics, it's all about non-state actors, lobbies, negotiators. We do not have good negotiators in Africa when it is coming to climate change. I also do agree with that we have to do that step by step. You know, at the national level, regional level, universal level. At the national level, we are still behind. We do not have the political will. It is still lacking. When someone said, priority for us is food, when it is about climate change, this is the last of our resource. So we have problem of corruptions. We have problem of lack of good governance. We have a problem when it is coming to new technologies, to this renewable energy. We even do not put how to say, we do not, le tri, yeah, we do not even know how to do that. So we have a lot of problems when it is coming to the national level, and I think we have still to do. Regional level, the same. We do not have solidarity among the African countries, and we have a gap of development between the different regions and the different countries. Coming now to the climate justice. This is, according to me, the last resort. And I agree with Yusra when she said the African court has a role. However, and you said, again, advisory opinion, it is not binding. I agree. But we have another issue, that is the Malabo Protocol, that have the fusion of the African Court of Justice and the African Court of Human Rights. Malabo Protocol takes us 14 other crimes. Among them, we can have something according to, there is some issue there. And that's why in my speech I said ecocide. This is a new crime, Yuskogas crime. These are the new norms. These norms are erga omnes. We even do not want text to that. And it can also, we can just put it in the international crimes against humanity if there is a political will to do. But I said, according to Malabo Protocol, there is one issue, I didn't found it, but I will tell you after. You know, 0 ratifications since 2013. 2 weeks ago, as I am OLC legal counsel, we have the first ratification of Angola, and maybe it will give the appetite to other countries so that we can go further with this very important court. However, if you can visit the website of the court, African court, 95% of the decisions, it is not even the advisory, are not executed. So what about the role of African court when as politicians, we do not execute any of them? And this question of ICJ, again, ICJ is fine, advisory opinion is fine, but it is not binding. We are all just trying to find some solutions, some issues, but it is not binding, unfortunately. That's why I raised this idea of the International Court of Environment, or Human Rights Court, and I saw a paper in Boston, here in Massachusetts University, 10 years before, 2013, about this idea of International Court of Environment. Maybe the future generation in Africa will never forgive us if we do not do anything. So maybe we have such networking, brainstorming. We need to connect each other. We need to bring new ideas. We need to negotiate. When you see the withdrawal of USA from Paris Agreement, when you saw these people, parole, they give us a lot of dreams, but they do not execute. So I have a lot of other things. I'm really optimistic, but I'm also realistic. So we have, I think, again, to work on ourselves, but also these developing countries, they have to assume their responsibilities, and this is our role to do the advocacy for that. Thank you.
Thank you. So I'm not sure I have actually 2 very, very brief questions. But first, I just wanted to say that today has been just a feast, and this panel was just the culmination of the excellent thought leadership that this conference has been since after I spoke. And of course, including the legal counsel for the African Union. And I completely agree with her. It's really good to see all these collaborative projects that people are talking about. And this panel, all the very important procedural, but it's also substantive questions, as well as all sorts of rights, indigenous, women's rights, children's rights coming together. And it's sort of first point I just wanted to say, I hope this is not the last time, just like Professor Gwildich has said, I hope this is not the last time we're having this conversation. because I think that all of you that organized this event are onto something. So that's the first point. So the very two quick questions is, when is this case going to be filed? Because I cannot wait. And why not, think of other venues where some of these problems might not arise, like the East African Court of Justice. But I also wanted to maybe suggest there's a flip side to all of this, which is that, I don't know how to say it, but I'll say it directly. The climate finance industry loves this conversation. And it loves this conversation because all the questions about vulnerability and the sacrifice zones, and I agree with all that, are precisely the opportunities, and the lack of finance are precisely the opportunities they are seeing. And they are succeeding in persuading many African governments that have already started getting into climate swaps and other types of borrowing in the context of climate finance. And so I know the minister this morning said that governments, including the Sierra Leonean government, are essentially taking food out of the mouth of children to address this crisis. Sovereign debt does exactly that as well. And there is a very big connection between the transactions that are being executed to fill the gap of lack of finance for all of the questions that we've been discussing today. And that is, we shouldn't lose sight of that. And so that language of vulnerability and the opportunities that the climate finance industry is seeing with all the sunlight in Africa, with all the vast lands, with all the forests. So there is another side. And I think that this is not to say we should abandon the arguments we are making, but I think we should be very conscious of the other side to this, the international economic law side. And sovereign debt is just one example. All these countries that have farmed out millions of acres of land for carbon markets. And one suggestion, maybe this panel just illustrates why it would be a wonderful idea to have a moot court on this question. Because I think that the new generation of thinkers, if we don't get to them, the people that are getting to them right now are the people who are defining all the things I've said in international economic law. The solutions lie in things like climate finance, things like, things like some technological solutions, which are really a pie in the sky. So I think that there is a really important, somebody had said this earlier in the day, there's a really important educational component. This idea should not be just at Austin Hall, whatever this Austin Hall is, at Harvard Law School in Cambridge, Mass. They need to go to Africa, and they need to go to Africa yesterday.
Thank you very much for the excellent presentation, and I just must say that I think something that really came up very clearly during the course of the presentation by the panelists that did a great job was the need to build synergies in how we construct knowledge on climate change. And I just wanted to ask a question, and the question relates to the notion of implementation. So when we think around providing solutions and through a rights-based framework, evidently there's the significant prospect that it gives us in terms of developing jurisprudence, but then also in terms of coordinating, having stakeholder actions, advocacy, institutional paradigms, and rest of that. But I wonder, at the place of implementation, are there specific examples that have come up in terms of how using the rights-based framework has led us to solutions around climate change? And it could be at various governance levels, it could be at the national level, it could be at probably the sub-regional level or the regional level. So I just sort of try, I think where I'm sort of coming from is a place of just thinking around the pragmatics of it. What solutions have we been able to come up with? Thank you.
So whoever of the panelists wants to answer, please go ahead.
I can go first. Ubuntu. Yes, we have explored Ubuntu. I'll actually say we one of the first questions we framed was, before we get to indigenous ethical and legal systems, the first question we asked was, is there such a thing as an African approach to climate, as an African approach to the environment? And anticipating the answer would be no. But the answer was yes. And that was a surprise. Ubuntu was part of that answer. We found a really surprising amount of consensus amongst African authors who mostly come from the philosophy departments, ethical ethics writers, some even medical ethics, bioethics writers, who across the board agree on a couple of things. For example, the African approach to the environment and to climate and to environmental ethics is collectivist, is communal, doesn't take the notion of the individual the same way as Western philosophy does, the notion of generations, like ownership, for example. Ownership of indigenous land or land in general is not just owned by the tribe or by the individuals, but it's also owned by ancestors who've passed away and future generations. And there is an anthropomorphizing of nature as well, where people talk to nature, talk to forests and things like that. And so overall, the consensus is similar to Ubuntu. They would, these philosophers would kind of percolate up into a certain form of an African philosophy of things that are indigenous, things that are pre-colonial, and kind of boil them into an African conception. Now that was surprising. So Ubuntu is one of them, but I would say also that's also something to be taken cautiously, because when someone who's educated and non-indigenous comes and says, I've boiled the indigenous conception down to an African-wide philosophy, that's something to look at with some suspicion. But surprisingly, there's a lot of consensus, and Ubuntu is one of those discourses. And Ubuntu is kind of a mixture and boiling up of Southern African traditions as well. Quickly on reparations, African solutions. African solutions I'll touch upon in two contexts. And I won't disagree with you, but I'll exemplify one thing. So when we talk about African solutions, so we are looking from a jurisprudential point of view, right? And so what would an African solution to global climate change mean in an African jurisdiction where the court, the commission, the sub-regional court has jurisdiction only on African states that are doing only 3% of the pollution, right? So that kind of limits you. And we're brainstorming one of the ways we could think about what could an African court do is, for example, can an African court decide that a polluter or someone who's responsible for, or a country that's responsible for climate change has a duty to pay reparations? I think we can go that far, right? But what does that look like from an African perspective? Maybe what it looks like is African states have a duty to demand reparations for their people. So that may be one jurisprudential area you could go to where, yes, the coastal community is gone, the African state isn't responsible for it. But that same African state is doing business with country X as if that country X hasn't caused this. So can an African court decide that you have a duty to demand reparations? So that's the kind of idea we're working with, and I'll take that to the sovereignty debt question as well. That's I'm not familiar with the sovereignty debt sphere, but I could imagine coming up with arguments in which can you use the human rights system in order to make demands on African states. And I do see those possibilities. Those are...
Thank you. I'll be very brief. I'm glad that someone had the insight to mention the word corruption. I don't hear it being mentioned here today. It's a point that is often mentioned by our Western partners when you talk about climate finance, when you talk about mitigation, adaptation, but more and more on loss and damage. So the question should not just only be about, the lack of money is the root of all evils. That seems to be I'm being self-critical as an African. That seems to be the way we're characterizing it. No, part of the question should also be, what is it that we're doing with the limited resources that we have with a view to address climate change-related issues in a way that actually complies with human rights standards? The other point that I just want to mention, I'm glad that the foreign debt issue was mentioned. During the pandemic, I'm just going to throw a couple of examples. During the pandemic, Zambia, their foreign debt was around 94.5% of GDP. Southern Africa was 82.2%. East Africa was 79.8%. So it shouldn't just only be Prime Minister Moti of Barbados that is actually screaming from the top of her lungs about the vicious cycle. It should actually be African leadership that are taking the charge, that are actually providing the intellectual leadership on these conversations. But you hardly see that happening, at least the Africa that I know, I hardly see that happening. A third point and last point, the sense of urgency, particularly from a child rights point of view. One of the things that I try to argue is that maybe the significant added value of the human rights framework, the child rights framework, is, as I said earlier, it would help us to address the adverse effects of mitigation and adaptation measures. Now, I'm just going to single out one that I think is significantly antithesis to children's rights, the notion that says net zero by 2050. I get irritated when I hear that often, because net zero by 2050 is like politicians loving the idea. They would no longer be around parliament. They will not be in power. They're just kicking the can down the road. And keeping in mind that currently, as we speak, 3/4 of the African continent has already made goal 13 of the SDGs. By the year 2030, there is no Western country that is actually projected to meet goal 30 at all. No Western country. So even though we're actually standing with that, we still have some of our countries still talking about net zero by 2050. That is antithesis to children's rights. We often say one thing that children do not have is time. 1 year in the life of a child is 6% of his or her childhood.
So really quickly, when is the case coming? So I'm aware that certain civil society groups are preparing a request for an advisory opinion. I don't have much more information about a timeline, but I think we can expect one, which is quite exciting. In terms of the question in the back about implementation and what that might look like and how that connects to reparations, there's a very recent case, actually, which was a decision which just came out from the African Court of Human and People's Rights, Ligue Ivoirienne des Droits de l'Homme and others versus Côte d'Ivoire, in which the issue was essentially an oil spill which led to 16,000 people suffering health consequences because of the environmental damage. And compensation was actually ordered by the court. So there is actually some kind of a precedent now about what that looks like before the African Court for environmental harm. And I think a lot of that can be translated into the climate space.
Thank you. Does any of our online speakers want to add a final remark?
I just want to say something that, just to clarify what I meant by African solution to African problems. It's all about taking responsibility because, we know this one climate system and, we cannot, as a continent, continue to push responsibility always, at all times, to the north. It is not a sign of maturity. So we need to take baby steps that we can on our own to address the consequences of climate change on our people. The issue of corruption is so key, critical and crucial because, so much money has come to Africa in the name of just transition. When NGO in the African continent ask government, how do you spend the money? It's a problem. They cannot account for it. And that is responsibility and that is lack of responsibility. So it's so important that even in the fight against climate change, we take baby steps on our own part to ensure that we address it, particularly on our populations. Thank you.
Thank you.
Yeah, I think for me, I would just like to end by saying that it is important to even understand what all of this means for Africa. And we've talked a lot about African position, Africa, but also whether we like it or not, the different countries are in different situations. And even within those countries, there are also differences across the populations. I think it's critical for us as a continent, countries, subnational, whatever we are, different levels of governance, to really sit back and try to understand how these concepts translate into meaningful outcomes for us, because that's the only way we can then take ownership and perhaps get to this, African solutions or homegrown solutions. Because otherwise, if it's all top down, global level decides, and then we're implementing, there will really never be that direct connection and true implementation. Thank you.
Thank you very much. And with this, please join me in thanking our panelists.
And I want to say Angela was an excellent moderator, so please thank her.